I beg to move that this House do now adjourn.
The question is that this House do now adjourn. Gavin Robinson.
Thank you very much, Madam Deputy Speaker, and can I, through you, thank the Speaker for selecting this topic for our adjournment debate, and I'm very grateful to the Minister who is in her place, and it's the first time, I think, since she's been in this role that we can engage in this way, so I look forward to that exchange. I do truly hope that we won't get 15 minutes elongation of the answer to the parliamentary question I got, which is that they do not wish to engage in this discussion at this time. But we shall see. There's plenty of time for it to develop. Madam Deputy Speaker, when you look at the title, the potential implications of the judgment in the case of Advocate General for Scotland and Mr Charles Milroy, I know there will be some asking the question, what has this got to do with the Northern Ireland MP? Or what has this got to do with the colleagues of mine that have kindly stayed in the chamber this evening? I can say, Madam Deputy Speaker, that I don't know Charles Milroy, though I know of his service. This afternoon I had the opportunity to speak with him for the first time, and I can recognise him as somebody who has served our country well over more than 3 decades. He joined the Territorial Army in 1982, was commissioned in 1983 and retired, having served his time as a reservist, as a commissioned officer, retired major, in 2015. And when he retired, he sought to attain what his co-workers successfully already had, which was a pension. And in 2015, this House will remember the work of the former Armed Forces Minister, the Right Honourable Member for Raleigh and Wickford, who introduced a pension for reservists. But Mr Milroy was not entitled, he was told, to a pension. And for almost 6 years now, he has been highlighting the legal entitlement that he has, and he has been pursuing that legal entitlement through the courts. And the law that lies behind that, as the Minister and colleagues will know, is the Part-Time Workers Prevention of Less Favourable Treatment Regulations 2000, introduced into our domestic law by the previous Labour government. An entitlement that puts together somebody who works on a part-time basis, somebody who works on a full-time basis, and assesses, is the part-time worker being treated less favourably than their full-time counterparts. And now on 2 occasions, Employment Tribunal and the Employment Appeals Tribunal, through the judgment of Lord Fairley in 29th of January of this year, have ruled that yes, he was being treated less favourably than his full-time counterparts. And the reason that I'm raising this, and the reason I think it's important to raise, having served in our Defence Select Committee for 8 years over the course of a number of parliaments, and taken an interest in defence issues and raised and championed cases not just for an individual, but for the collective endeavour placed in service in this country, I raise it because of the fundamental important principles that lie behind this singular case. Of course, I'll give way.
First of all, Madam Deputy, can I commend my honourable friend and colleague, the member for Belfast East, for bringing this forward. I met the Pension Society guys on Monday. I didn't know that my colleague and friend had actually got the adjournment debate in this, but whenever I showed it to them, they were incredibly interested, and they want to put on record their thanks to the Right Honourable Member for doing this. My learned and Right Honourable friend understands much better than I would that Northern Ireland has identical legislation, provides the same protections for part-time workers, and subsequently this will have a huge impact on Northern Ireland Reserves. I declare an interest, Madam Deputy Speaker, as one who served in the part-time as a part-time soldier for some 14.5 years. Does the Right Honourable Member not agree with me that we must ensure that this process is handled quickly? Urgency is of the importance to ensure that we right the wrong, stand with our ex-service personnel who should never have to fight their government, their minister, for that which has rightly been theirs.
I'm very grateful to my honourable friend, and I do want to come on to the scope of this in a moment, Madam Deputy Speaker, but I don't disagree with the points that he has made. And when I mentioned earlier that I had a brief conversation with Mr Milroy this afternoon, I recognised him in the way he engaged with me and the way he outlined his experience in this to be a true gentleman. I recognised him as somebody who for the last 6 years has fought to assert what is a legal entitlement now accepted by 2 courts within this land. I also recognise him to be a gentleman who was more interested, still having served as a senior military leader, more interested in those who lay beneath him, those who he led, those who he still holds a pastoral and benevolent support for. And he indicated that over the last 6 years of this quest, having won 2 years ago and won again in January, that 3 of his colleagues, comrades, individuals that he led have died.
The Honourable Member Gavin.
Yeah.
Thank the Honourable Member for giving way. Thank you, Madam Deputy Chair. In terms of this judgment, would the Honourable Member agree with me that with over 40,000 members of the Ulster Defence Regiment, and half of those, about 20,000, were part-time members of the Ulster Defence Regiment, in light of this ruling, does he believe that they should be entitled to a pension as well, as I believe they should be?
Thank you. We'll come back to the point of scope, which is what I mentioned to Honourable Member. I do appreciate the point that the Honourable Member for North Down has made. But I do lament the fact that I was outlining that somebody who has been campaigning on this issue, particularly and personally and with colleagues for 6 years now, has lost 3 comrades in the process, never to attain the legal entitlement that they have. A legal decision set by Lord Fairley, as I say, the President of the Employment Appeals Tribunal across England, Scotland and Wales, somebody of legal standing, and an issue that I imagine is engaging not only principally individuals in Ministry of Defence, but also those who are engaged in finance. Because there is a scope issue here, Madam Deputy Speaker. I understand entirely, and I will always champion those who served in Northern Ireland, be it in the Royal Irish Regiment more recently, and Home Service battalions particularly until their disbandment in 2007, or indeed the Ulster Defence Regiment. But we cannot assert legal positions that didn't exist at the time.
Would my right honourable friend give way?
And the Ulster Defence Regiment disbanded in 1992, some 8 years before this legislation was brought in the United Kingdom. Now, particularly because we can look at those who have served as reservists from 2000 or 97 right through to 2015. We can look at the scale of that. We know that in 1997 there were 130,000 reserve personnel in the United Kingdom. In 2000, 110,000. In 2015, 85,000. We know at the time in 1997, for example, when this legislation was introduced on a European basis, that there were 1,870 reserve or part-time members of the Ulster Defence Regiment. But we also know this. That's not the case before the MOD today. The case before the MOD today is one of principle in Major Milroy and those of his co-claimants that are already in the system. The Minister should also know well that there will be impediments through statute of limitations to further and future claims. And there is an opportunity for the Minister to consider this case, and I will come back to it in a moment once I take this intervention, to consider this case and those who have travelled alongside Major Milroy, rather than worry about a scope which could be exponential, but for time, sadly, has already passed. I'll give way.
I thank my right honourable and learned friend for giving way and also bringing this debate today. Whenever I wrote to the relevant minister a year ago, the MOD confirmed that there were at least 310 people in Northern Ireland that fell within the scope of this, but I do agree entirely on a point of law, that there is absolutely no point in the government deciding to fight this or to seek in any way to curtail this, and should indeed now accept that they have lost on this point of law and therefore allow anyone eligible to benefit.
I'm very grateful for that intervention. I think the time is coming, at least though we might not hear it this evening, that the Ministry of Defence need to engage in the reality of what has been asserted in the courts. And the Ministry of Defence is going to have to accept that at a time when I and my colleagues and others throughout this chamber are raising issues around support for veterans, particularly in light of the Northern Ireland Troubles Bill, and particularly in light of the challenges that the Minister knows well and has engaged with me in debate on some of these issues in the past, will know that I personally challenged that this Labour government is not bringing forward safeguards for veterans, was told that they were, was then told that I was right and the Prime Minister was going to bring forward amendments to their own bill, which they already said had protections. We haven't seen those amendments. We haven't seen the nature of those amendments, but stand here tonight and there's but yet another example of how this government has an opportunity to demonstrate the recognition for the service of reservists and veterans, has an opportunity to demonstrate that whilst they recognise there will be a financial implication, there is a moral impediment to honouring a legal commitment that a previous Labour government brought through and applied in this country. In recognising, we hear internationally all the time from the Labour government about the need to adhere to international laws. Well, what about adhering to the ones brought in by themselves in our own country? And honouring and recognising the sacrifice and the service of so many, as I know the Minister served herself, of recognising so many who have served our nation. So that is one of the challenges. Second challenge, I think more clearly, is that the Minister will need to, if not today, give an outcome to this process, but today indicate I think the Minister does need to indicate, Madam Deputy Speaker, that the Ministry of Defence are interested in a particular analysis and in implications of this case, that they have a fair understanding as to how they're going to deal with it, and they will work towards a resolution. The last thing this Labour government wants to do is to appeal to the Court of Appeal and then appeal to the Supreme Court and give not only the impression but the actual fact that they will exhaust every opportunity to deny a legal right that is there and has been asserted on behalf of our veteran reservist community. It would be an indictment on this Labour government if they were to exhaust ad nauseum every appeal mechanism and opportunity to frustrate the legal entitlements of our service veterans. I don't think they will be able to stand here today and honourably say that's the position they wish to adopt, or stand here in 3 weeks' time and talk about the Northern Ireland Troubles Bill and how much protection they afford to veterans when they can't get the basics right. I know the Minister is not responsible for what's gone before, but she has the opportunity to address not only the perception but the reality that has been faced by Major Milroy and by his co-claimants and by those who have a legal entitlement that they are asserting. An opportunity to redress the harm that has been caused over the last 6 years, an opportunity to ensure that this Labour government does not pursue endlessly appeals to thwart entitlement. And it's similarly true with the MacLeod judgment. The MacLeod judgment applies to the Ministry of Defence. The MacLeod judgment is still being worked through unsatisfactorily and unsuccessfully so. So I raise this evening, Madam Deputy Speaker, in the earnest hope but limited expectation that the Ministry of Defence, through the Minister this evening, will at least give some certainty that this won't be a dragged out endless process through each and every subsequent court there can be, Court of Appeal and Supreme Court. I understand it's under consideration. I understand there will have to be an assessment of what to do. That should not happen until there is a full understanding and analysis of the implications of the judgments thus far and the real prospect of any successful appeal. There won't be. The entitlement's there. It's been asserted in so many other spheres and sectors and asserted here in these cases. And I can tell you very clearly, and I heard it this morning from colleagues on other benches where they said that these guys didn't serve for a pension. No. They served under the leadership and guidance of the Ministry of Defence, of their senior command. And this is an example where they're saying, well, hang on a second. Maybe in service I took the orders I was given, but in retirement I'm at least going to ask, are they lawful? Do the laws apply to us too? Do we have legal entitlements and protections that we can avail of? And I think this is the opportunity for government to say, we recognise your service, we recognise all you did for us, and we will not, through hook or by crook, deny you the legal entitlements and the recognition of your service that you so richly deserve.
Minister.
Thank you, Madam Deputy Speaker. And I thank the Honourable Member for securing this debate and for the contributions that have been made by him and across the House. I know and can see and hear he's a very passionate champion of veterans and reservist rights. And as a veteran myself, I thank him for his commitment and very hard work on behalf of those who have served so much and contributed so much to our armed forces. As he notes, the case of Advocate General for Scotland versus Mr Charles Milroy does raise important questions, not only in law, but in how we recognise and support those who serve and have served our country, including through reservist service. So let me set out the government's position. On the 29th of January 2026, the Employment Appeal Tribunal in Scotland handed down its judgment in Advocate General for Scotland versus Mr Charles Milroy, and it upheld the earlier tribunal's findings in relation to Major Milroy's service and the application of employment protections to reservists. That judgment is being carefully considered by this government. What I will do this evening is explain the principles guiding the government's approach, the work already underway, and the position we are taking to support reservists and employers. So firstly, on our commitment to reservists. Reservists are, of course, integral to the effectiveness of our armed forces. They bring vital expertise into defence, strengthen operational resilience, and provide specialist skills that can't be generated or sustained within the regular forces alone. As the Secretary of State has said during the second reading of the Armed Forces Bill last month, our reserve forces are crucial to Britain's security and, if necessary, to achieving a sustainable, effective and rapid transition to war. Their contribution directly enhances defence's capability. The government's position is clear: reservists must be treated fairly, lawfully, and with proper regard to both their military service and their civilian employment. And that principle underpins our policies and will continue to do so. Secondly, on pensions and the historical context, it is important to place the pension issues raised by this case into the correct historical context. The questions before the tribunal relate to an earlier policy framework, and since 2015, reservists have had access to the same pension scheme as their regular counterparts. Moreover, reservists have long been entitled to pension provision during periods of mobilisation, recognising the fact that they may be placed directly into harm's way while serving on operations. And that protection remains firmly in place today and should not be lost in the wider public discussion of this case. Third, on the judgment and the government's considerations of next steps, we must be clear about the particular facts of this case before the tribunal. It was found that aspects of Major Milroy's reservist service engaged employment protections in a way that had not previously been recognised. Both the Employment Tribunal and the Employment Appeal Tribunal expressly acknowledged that the level of service days in question was atypical. That finding raises legitimate and complex questions about how certain forms of reservist service are characterised in law and how they interact with employment-related rights, including questions of pay and pensions in this individual case. As such, the government is carefully considering its implications for the judgment. That work is ongoing and it is being carried out while the case remains within the statutory period during which an appeal may be brought. It would therefore not be appropriate for me to prejudge the government's final position at this stage.
thank the Honourable lady for giving way. I know she has served herself and comes at this from very much a service background. Time is of the essence. The Honourable Member from Belfast East made a powerful point about 3 members of the McElroy reservists having passed away. So today I'm not hearing a clear timetable for implementation. I'm not hearing that sufficient funding has been allocated, and I'm not hearing that the government are in the process of actually bringing forward an impact assessment report detailing the number of affected reservists, the estimated financial liability, and the department's actual plan for redress. Can she go further and give hope to those reservists that the government is actually going to do something on this?
Well said.
Wouldn't be appropriate for me to comment on the details, but I can assure her we are considering the implications of this judgment very closely, and I'm very mindful of the point that both she and others have made about the need for speed on coming to this judgment.
Of course, the government is considering whether or not to appeal. I trust it doesn't. But if it doesn't, and this is the end of the legal road on this, then the government is faced with the next stage, which is what is the remedy model it's going to develop for this case. Could I appeal to the Minister that in arriving at that model, they do not make it tight and narrow specifically to this case, but they base it on the emerging and very strong principle of this case, that there has to be acceptance that part-timers should have pension rights. That's the fundamental principle in this case. And therefore, if the government seeks to avoid that by focusing only on this case and on the reservists, but ignoring the wider cadre of individuals who are equally part-timers and denying them what they will have to give to this applicant, then wouldn't that be a very wrong-headed approach?
I thank the Honourable Member for his point, and his comments have been noted, and as soon as I do have further details I will update. Several members have spoken about the importance of confidence amongst reservists that their service will be supported.
Madam Deputy Speaker, can I commend the Honourable Lady? She's a gallant lady, and we understand that she's an intention personally to try and make things better. But whenever I met the pension people on Monday, they were saying that there are many part-time soldiers aren't aware of their rights, aren't aware of the fact that they might be able to claim. Is government and the Minister in particular making any efforts to try and contact all of those soldiers to ensure that they will be aware of their rights and can claim? Because as the right honourable member Belfast East referred to, the longer it goes on, some people will die, pass away, and the opportunity and the opportunity for money should also go to their relatives, should be retrospective.
I thank the Honourable Member for his point, and I'm not in a position to give details at this point, but I'm absolutely taking into account his comments and make sure that they will be considered and note his concerns. Confidence amongst reservists that their service will be supported. Confidence amongst employers that the framework within which they operate is clear and predictable. The government's objective is a framework that supports reservist service, provides clarity for employers, and is fully consistent with the law. Where the Milroy judgment indicates that greater clarity is needed, we will address that. Where it confirms existing arrangements, we will state that plainly. Finally, on the wider message to those who serve, reservists across the United Kingdom make a substantial and valued contribution to our national defence. This judgment and the debate it has prompted reinforce the importance of ensuring that our systems reflect the realities of modern service and continue to command confidence. So in closing, Madam Deputy Speaker, the Government will give full and proper effect to the judgment in Advocate General for Scotland versus Mr Charles Milroy. We are considering its implications very carefully, engaging with stakeholders, and will act where action is required. We will do so in a way that is lawful, proportionate, and firmly grounded in fairness. I again thank the Honourable Member for bringing this matter before the House and to everyone who has contributed to this important debate. Thank you.
The question is that this House do now adjourn. As many as are of that opinion say aye.
Aye.
The ayes have it. Order, order.